guess we've
Oh, I see. Okay. So.
got a quorum here. Let me call the County Ethics Committee Commission to order. And if Ms. Jones comes in, we'll set her down as she comes in. So let me call the meeting to order. On roll call, we don't need that. I guess we know who we got here.
I'll just call it for you.
All right.
Commissioner Jones. Commissioner Renee.
Present.
Commissioner Peck.
Here.
And Commissioner Tomac.
Sure.
Okay. And then we've got one resignation on the board, so that commissioner is no longer on the commission. Three is the agenda review. I'm not sure what that specifically is.
Judge, just as an informational item, we have patterned your agenda now after the Board of Supervisors format,
Okay.
and primarily because the clerk is using the same recording system. And you'll see that we have an opening which has kind of your administrative details prior to starting any action on any items, and then your consent agenda, which is non-controversial items that really are just receive and file, regular items which require action, and then correspondence, which is also generally receive and file. This would be the time that if there were any changes to the agenda, items that needed to have some modification brought to your attention, we would bring it to you at this time.
Okay.
And there are none for this meeting.
The agenda, the record should reflect that Commissioner Jones has also joined us. It's all right. It's raining outside. Where I was going with this was wondering, would this be an appropriate time? Mr. Williams has indicated that he had items. I don't know what they are. Would this be the time to at least consider them?
I'm going to defer to counsel on that. Matt, do you think that this would be an appropriate time for Mr. Williams to make his presentation, or should that fall under public comment?
Probably follow the agenda and whatever cards he's put in. He can speak to those items along with any other members of the public who care to do so.
That's not the answer that I requested.
Well,
I requested a point of order.
well, I'm somewhat at a loss because I don't have any idea what it is we're talking about.
It has to do with the agenda. I'll fill out a card for number 3.
Well, let me just do this because I'm more or less at a loss. What is it that, Mr. Williams, that you're interested in at this point?
Thank you, Mr. Chairman.
I reserve the right to cut you off if I decide it's
I'm going to be very direct.
Okay.
On your correspondence agenda, I asked to show a DVD, and I did not get an answer till Tuesday, and the answer was positive, but I'd like to have that shown. It's only a minute and 15 seconds. I'd like to have it shown under the public comment sections, and then I will speak to agenda item 10, 11, and 13.
Okay. Does the DVD that you're going to show have anything to do with any of those 3 items?
No. No.
What does it? Is there a place on the agenda where
the DVD presentation has to do with Government Code 54956, that this board may not prohibit criticism of its policy. That's what that DV is directly addressing. Is my right to publicly criticize, and I chose to do that under public comment. But in dealing with the clerk, Ms. Thompson, or Dale,
Tompkins.
I'm sorry, I was advised to put it on the correspondence agenda because it's a DVD and it's not in written form, it's in picture form. It's all prepared.
Okay, I'm smiling because I'm not sure I know what it is we're talking about here.
The clerk has it all prepared for it to be shown. It was shown Tuesday at the board meeting under public comment as under criticism under the Government Code.
The DVD on the agenda I have in front of me is item 18. It says receive and file letter requesting a DVD presentation.
All right, if you prefer for me to show it then, I'll show it at item 18 then, if you prefer that.
Yeah, well, I was trying to find out if it had anything to do with the other items. If it didn't, then in fact probably we can do it under correspondence.
No, it has nothing to do with the other agenda items.
Okay, then, because if it didn't, if it had something to do with them, then I'd say, well, do it at that time.
It does not, Your Honor.
Okay, well, let's take it under item 18 then.
Thank
That's
you.
all right.
Thank you.
Okay, moving on, they approved the minutes of September 13th, 2006.
Move to approve. Second.
All in favor? Aye. Okay, the minutes are approved. Number 5, public comments. Okay. Yes, Mr. Williams, you have a card on under public comments.
Carol Dean Williams, a 61-year resident. I want to set the record straight. At the previous meeting, this was my exact quotation. If you make decisions when you don't know shit about a subject, you are an asshole. Thank you.
You want to put that on the record?
Yes.
Okay. All right. Any other public comments? Number 6, commission member comments.
No comments.
Item 7, consent agenda items. Any consent agenda items?
That would be for items 8 and 9.
Okay, 8 and 9 does anybody wish to be heard on either 8 or 9? We'll receive the letter of February 1st if not, and we'll file a letter of resignation on Commissioner Peterson. And then going on to item 10, I gather.
We have a motion, please,
Need,
on the consent agenda.
you need a motion on a consent agenda?
I need to actually, what you're doing is you're receiving and filing both of those items.
All right. On 8 and 9?
Second.
Or moved and seconded, all in favor? Aye. Opposed? They're received, filed. All right, item 10, a ratification of a notice of a finding of no probable cause on an allegation against now Supervisor Peter Foy.
Yes, Chair Peck and Commission members, this item is brought to you for ratification of finding of no probable cause on a complaint filed by Carol Dean Williams against the group Peter Foy for supervisor. The finding of no probable cause is attached to the notification indicating no probable cause.
Okay, and everyone has a copy of that in their agenda and has read it?
Yes.
Okay, Mr. Williams, you have a comment on that as well.
Thank you, Your Honor. This comes under Section 1289, and this was on a website, and I was able to print it off under the definition of the word print that Ms. Jones said did not qualify for print. She is wrong, she is in error, and this board needs to correct that. Thank you.
Okay, any other comments on the ratification and the finding? Anybody wish to move it?
Move approval.
Okay,
Seconded.
moved and seconded. All in favor? Aye. Opposed? We will ratify and file that. And Mr. Williams, your comments are noted. Item number 11, dismissal of case 2006-01 regarding Judy Michaels.
Good afternoon, Mr. Chairman, members of the Commission. I'm Craig Steele, Richards, Watson, and Gershon, the investigator on this matter, 2006-01, a complaint filed alleging a violation of the county's campaign finance limits. Specifically, the complaint alleges that Supervisor Michael's campaign committee violated Section 1268 of the ordinance by soliciting on her website contributions in excess of the county's contribution limit. We have investigated the matter and determined that, in fact, the ordinance prohibits the making of a contribution in excess of that limit, the acceptance of a contribution in excess of that limit. It does not prohibit a solicitation of a contribution in excess of that limit. In fact, the solicitation was apparently left over on the website from a prior campaign. The complainant printed pages from the website, turned those in with the complaint. The website was later changed to conform to the county's contribution limits. A review of the contribution records from the campaign indicates that no contribution was ever accepted in excess of the limits, and because a solicitation of a contribution, even if it was inadvertent and temporary, does not violate the language of the ordinance, we are recommending that this matter be dismissed without a finding of violation. I'd be happy to take any questions.
Anybody have any questions? I gather the solicitation, if that's what it is, drew no takers. Is that what you're saying?
That's correct.
Okay. Thank you.
Thank you.
Mr. Williams, you had a comment.
Geraldine Williams, when Supervisor Michael signed the agreement to limit her contributions in June, which this occurred after that, and every other candidate made it plain and posted on their website that they could not accept over $600, and to sit here and say a candidate can solicit $5,000 is ridiculous, and you all are a bunch of jokers. You are a bunch of jokers to sit here and tell me and the public that a candidate can solicit $5,000 when there's a $600 limit. It's time for the joker to come in and laugh you people silly.
Mr. Williams, you'd be a lot more effective if you were more temperate in your remarks.
Judge Peck, this body has already made its decisions, and I know what they are.
All right. Any discussion on the matter?
I believe that was mine, and I think I found probable cause.
Well, do you want to?
It seems a bit splitting hairs between.
Do you want to discuss the question of whether or not it should be a violation to solicit, whether or not the solicitation results in any fundraising?
I'm just reading this for the first time, and my understanding is that because the language of the ordinance doesn't prohibit solicitation. Sorry, so is the finding based on the language of the ordinance doesn't prevent solicitation, or the fact that there were no takers? What is the basis of the decision?
Both are the basis of the recommendation. The language of the ordinance prohibits the making of a contribution in excess of the limit and the accepting of a contribution in excess of the limit.
But
both
not the soliciting?
But not the solicitation. And both making and contributing are well defined in state law. In the ordinance, there is no question what is making, what is accepting. The ordinance itself does not at all prohibit the solicitation of.
Is that a problem with the ordinance? Because it seems like if you can't make that type of donation nor accept it, soliciting it.
I obviously was not here when the ordinance was drafted. Some ordinances prohibit making, accepting, or soliciting those contributions expressly. A basic rule of statutory interpretation is, as I'm sure the judge knows, if the legislative body lists things to which the ordinance applies, we presume that those things they don't list don't apply. And in this case, because the board listed making, listing accepting, and didn't list soliciting, we have to presume that they didn't intend for the ordinance to apply to this particular kind of case. And that's one basis for the recommendation. The second is that, in fact, according to the records of the campaign, there were no contributions in excess of the limit accepted.
Anything further? Let me make a suggestion, if it's the commission wants this. Do you want to send this over as an informational item to the board as to whether or not this was their intent? Because I right now I tend to agree with you that if it's okay to solicit it as long as nobody pays, he sends the money in.
Or if they do, you don't accept it. It just doesn't
it
add up. I respect what you're saying, but I don't think that's the intent of the ordinance.
That's not a criticism of your recommendation, but it is a question that might want to. But it's something that I would like to send to the board, because if the board thinks this is sufficient, then I'm all right with it. But
and I will just, for informational purposes, and I'm sure Mr. Wucher may have some additional input on this, some entities, when they're adopting these ordinances, feel that they want to restrict as little speech as possible. Just narrow it down to the actual acts that they think present the appearance of corruption in the political process, and so they are very, very tightly drawn to only those things we really want to prohibit. It may be the case in this ordinance that thought process is a part of the absence of the word solicitation. I don't know. I know that some ordinances read like yours, other ordinances have the word solicitation in there. It's just a legislative choice. And as I say, I was not here, so I don't know the basis for that choice, and can only act on what the language is.
One of the problems, I would think, if you had solicitation in the ordinance, people might accuse others of soliciting by word of mouth, and
that's a matter of proof.
Yeah, that'd be difficult to prove, but it would be.
This was on a website. This was
right.
Right. And I understood at the time that it was a leftover, but it was nonetheless on the website. So.
Right.
I think I would agree with Judge Peck that it should be sent back to the board.
Well, I'm not. Just to make clear, I'm not necessarily suggesting that we consider that change right now, but I would like to send it to the board as an informational item to get their reply to it. After all, it is their ordinance.
Correct.
And if they agree with us, then in fact I would certainly go along with that change. Is that sufficient here? I don't mean to.
No, I think that's sufficient. I think that's an excellent idea. I think another thing that changes the complexion of this particular situation is that it was obviously an oversight and clearly a website for Nichols for State Senate.
That's a wholly different act. That's a different thing.
It wasn't clearly. There were both things on there. And
okay, well, I didn't see the website, but I mean that's what's pointed out here.
That both the supervisorial race and the Senate race were both on the website, and then the solicitation was on a separate page, as I recall. But you're right. Solicitation isn't in the ordinance. So.
And I frankly didn't feel the need to move to, well, was it a leftover? What was the purpose of the website? Because I stopped at an issue prior to that. I felt compelled to look only at the language of the statute itself, and that's where the investigation comes to you.
Thank you very much.
Thank you.
Thank you.
What do we need to do to send an informational item to the board requesting their guidance.
We'd be happy to take something to the board to advise them that there was a concern on the part of the commission concerning the lack of a definitive word solicitation in the ordinance as it pertains to this case. We can do that.
Yeah. There's a feeling that it's a distinction without a difference. And we'll request that then. Do you need a vote on that, or?
I guess we need to know what you're going to do with this particular case. Are you going to continue it? Are you asking the item be continued and brought back after the board makes that determination?
I don't know. I was thinking of a separate item. The way the ordinance now stands, the recommendation probably is a valid one. The question is whether is in the future whether or not we want to change the ordinance. That was my.
I would move to accept the recommendation.
Okay. So then do another motion probably to
Right.
send it back.
Okay, we have a move seconded.
Accept the recommendation.
Yes,
Of
yes,
dismissal.
on this
Yeah.
item.
Second.
Okay, moved and seconded. All in favor?
Aye.
Aye. Okay. And then a second, do you want a motion on that?
Yes, please.
A second motion would be to send the problem to the Board of Supervisors for their guidance and report back as to how they want to proceed. And we can then take it up from there.
Whether this is an oversight or whether this was their
Yeah.
intent
Yeah.
because of freedom of speech.
Yeah.
Do you move on that one?
Yeah, so moved.
Okay, seconded?
Second.
Seconded.
Thank
Okay,
you.
all in favor?
Aye.
Aye. Okay. All right. We've finished that, I think. Thank you very much, Mr. Steele. Item 12, dismissal of case 2006-12A regarding Linda Parks. Recommendation of Mr. Hardy.
Good afternoon, Chair and members of the Commission. My name is Ken Hardy. I'm an investigator in case number 2006-12A. As you can see, I've submitted a recommendation for dismissal in this case. I have a report of findings and a proposed order attached with that. If you wish, I could go over in summary the statement of findings.
Yeah, I've got these in fax form, and they're not stapled together, so I'm looking for them here.
Well, let me tell you
Yeah.
briefly what it says. In essence, an individual by the name of Joseph Gibson filed a complaint, and the Elections Division also filed a complaint, claiming, in essence, based on the probable cause determination, that there may have been a expenditure by a Louis Masry for a newspaper ad that was not an independent expenditure.
Yeah.
That was my reading of the materials, and I think that is the essence of the complaint after reviewing everything. If that was not an independent expenditure, then Louis Masry would have exceeded the $600 contribution limit to the vote for Parks Committee, and the vote for Parks Committee in turn would have received an amount in excess over $600. I did conduct an investigation and had an interview with Supervisor Parks, Louis Masry, and Joseph Gibson, and I could not find any evidence that the expenditure for the newspaper ad was made at the behest of the Linda Parks Committee.
The Masrys simply did it?
Based on the evidence, there is evidence that they have a relationship in the past, certainly, and that they know each other, and that Supervisor Parks was a council person with Louis Masry's father sometime in the past. But there was no evidence either in Mr. Gibson's letter itself. It speculates that there might be a connection, but there's no specific allegation that there was a connection in Mr. Gibson's letter. all of the material that Mr. Masri used for that newspaper ad was available from Ms. Parks' website, and his own photos from his father when he apparently, Louis Masri's father, ran for city council at the same time that Supervisor Parks did. So they had photographs together. So
Was the Parks Committee itself contacted to see if they knew of any connection?
I spoke only with Supervisor Parks. She informed me that she was the treasurer of that committee.
She was what?
She was the treasurer of that committee.
Okay. Did she know about the ad?
No, she did not. Not until after it was published.
So you're recommending that we...
I'm recommending, based on the evidence that I found, that this matter be dismissed because there's no evidence to support the allegation that there's been a violation of the ordinance. I spoke to Mr. Gibson as well and asked him if he wanted to add anything above and beyond what he put in the letter, because what I was looking for is some specific allegation as opposed to just a conclusory allegation. And Mr. Gibson did not. He informed me that he did not have any additional information to add.
Okay. Any other questions, Mr. Hardy? Thank you very much.
I do note that Supervisor Parks is in the audience as well.
Yes.
Thank you.
Mr. Williams, you wanted to make a comment.
I'll pass on that one. I wasn't clear when I was going over the agenda. I thought it referred to one of mine, but it doesn't.
Oh, all right. Thank you. Any other comments or remarks? We need a motion.
I would move to follow the recommendation.
I would second, based on the assessment of the credibility of the witnesses.
I don't ordinarily question, but I did in this case because I know there's a relationship there. All right, I'm not a fool. The question is whether or not, though it is a violation under our own rules, and I gather suspicions aren't evidence.
I think that's why we have an investigator who talked to the parties and found them to be credible.
Yeah,
So,
I guess so.
but I agree.
Okay, any other comments?
It's like the bubbling one, No, we don't need to.
Okay, anything else? If not, let me call a question. All in favor?
Aye.
Aye. Opposed? Carried. Thank you. Item number 13, dismissal of case number 2006-1 or -14. Peter Foy, Mr. Steele.
Yes, thank you again, Mr. Chairman, members of the Commission. Craig Steele, investigator on number 2006-14. This case is an allegation that the Peter Foy for Supervisor Committee accepted a loan from now Supervisor Foy and refused to provide a copy of the written loan agreement to a member of the public when the member of the public, Mr. Williams, made a request for it. The ordinance provides that Section 1293 of the ordinance provides that each county candidate and committee shall deliver on demand to the commission or to any public officer having authority to enforce the ordinance an authorization to allow that officer or the commission access to records of the committee. Apparently during the course of the campaign there was an email exchange between Mr. Williams, the treasurer for the committee, and Virginia Bloom in the elections division. An email from Ms. Bloom to the campaign caused, I think, some misunderstanding on the part of the complainant as to whether or not he had a right to receive a copy of that agreement from the campaign itself. It is true, and I've had a rather spirited discussion with Mr. Williams about this earlier today.
As you can tell, so have we.
Yes. And I respect Mr. Williams' opinion on the issue, but it appears that he interpreted that email to mean that he was entitled to receive documents directly from the campaign. Clearly, however, the ordinance says that if the county, this commission, an authorized public officer, requests a copy of a document, that document has to be provided, or access to those documents has to be provided. And then under the Public Records Act, once that document is in the possession of the county, it becomes a public document. So if, in fact, the loan agreement had at the time of the email exchange been in the possession of the county, and it was not, it would have been a public document. Mr. Williams, anybody else could have walked in at the time and received a copy of it. It was not here at the time. Nobody had ever asked the campaign for it. The campaign was not required by law to affirmatively file it with the county. In a pre-hearing conference that I held with Supervisor Foy, I asked for a copy of the loan agreement. I was nearly immediately provided with it within a few days with a copy of it. Supervisor Foy, and that document is on file here at the county now. Supervisor Foy also informed me that his treasurer had in fact actually provided a copy of that document to Mr. Williams at some point as well. So Mr. Williams actually did get a copy of the document from the campaign, even though it was not legally required to provide it directly to him. So it appears that the complaint may arise out of a misinterpretation of what the ordinance requires. My investigation found that the loan was documented. The document was provided to an officer of the county when it was requested. It was in fact provided to the complainant according to the campaign, and we find no basis for seeing that the ordinance was violated, and we're recommending that this case be dismissed.
Do you, to go just a little beyond that, because I don't necessarily, on the basis of what I think I've heard, disagree with you, and certainly a member of the public probably doesn't have a right to demand of the county that they obtain whatever documents the member wants. But on the other hand, if the documents are in the possession of the county, or if the county in their judgment feels that they should be requested, that would be the way in which a member of the public would be able to go about it. Am I correct?
Absolutely. And I tried to tell Mr. Williams that if the county at that time had a copy of that loan agreement, but there was no law that said the campaign had to furnish it at that time, if the county had a copy of it, and if the county has a copy of it today, it's a public document. Mm-hmm. There's no question about that. It's a public record. People can get copies of those documents. There's no basis under the law for keeping them confidential once they come into the possession of the county. At the time, however, nobody had asked the campaign for it. It just had been reported as a loan. Nobody was auditing the campaign or anything like that. There was no reason to have asked for a copy of the document. It wasn't in the county's possession. There was no way to give it to Mr. Williams. There was this email that said from Ms. Bloom to the campaign saying, sure, that's a public document. And I think Mr. Williams interpreted that to mean he was entitled to get it from the campaign, when I think, in fact, the Elections Division meant that if we have it, it's a public document. So that's as near as I can figure out how the complaint arose. That's my supposition. It's not really relevant to whether or not there was a violation. In fact, there was not a violation of this section of the ordinance.
Okay. Anybody else have any questions of Steele? Okay. Thank you very much. Mr. Williams.
Thank you, Honor. How much time do I have left?
How much?
2 minutes, 58. Yeah.
I'd like to quote from the April 9, 2007 letter from Mr. Steele. In her reply, Ms. Bloom said the agreements were public records which the public has a right to request, unquote. That was the information I was given. If this campaign ordinance is so screwed up that the people that enforces the election can't understand it, and only after the campaign was informed of that did I get a copy. He has contradicted his own deal of what election said, that it was a public record. Why was I told what the ordinance really meant then?
Well, what you just quoted to me doesn't in any way, shape, or form, in my mind, disagree with what Mr. Steele said. It is a public record. He said it's a public record. It just wasn't in the possession of the county at the time.
If it was a public record, I sent the campaign an email requesting that public record, and they refused to produce it.
You asked it of the campaign committee for who was it, Mr. Ms. Supervisor Foy. If you'd have requested of the county, and if the county had it, you would have been entitled to it.
I did request it from the county. They said it should be kept with the 410 filings.
You have it now, right?
Yes, but I didn't when I filed the complaint, and that's why a complaint was filed.
All right. Anything else? Do we have a motion? We have a motion. Seconded. All in favor?
Aye.
Aye. Opposed? Carried. Item 14 is the recommendation for a stipulation and order regarding now Supervisor Foy from Mr. Hardy.
Yes, Honorable Chair and members of the Commission, I investigated case number 2006-08 with Peter Ford for Supervisor Committee as the respondent. What you have before you is a stipulation and findings and proposed order with respect to this case. This was a fairly simple case. Two individuals made $300 contributions to the Foy Committee.
Both in their individual name
in their
and
individual
in the name of
capacities.
the business.
And then there's basically an additional $600 contribution by the company that they both owned. Therefore, there was an overage of $600 by the Foy Committee in receiving, in essence, $900 from, for example, the husband, and then an additional $600 from the company that the husband controlled. I interviewed Supervisor Foy, and he admitted to the violation, as you can see per the stipulation. And I have recommended, since this is a first-time offense, if I can call it that, and there's no aggravating factors, and there was cooperation, and the amount is under $1,000, I recommended no fine be imposed in this case, even though the order would show that there was a violation.
Is that because of the amount, or is that because of the other circumstances?
Well, let me preface this. There are no, as of this time, real guidelines on imposing fines for violations of this committee, so I did do a little research on how other cities and counties handle this. And I know, at least in other counties, the city of Los Angeles, for example, has a $1,000 threshold. First-time offenders are not fined. Under the city of Los Angeles system, I thought that was reasonable. But both the fact that it's under $1,000, as well as there was no history of violations, as well as there was full cooperation, all of those combined led me to make the recommendation. I do respect the Commission having their own determination on what they want to do in this matter. The stipulation, of course, is contingent upon approving the order as written. If you feel that a fine is warranted in this type of case, that's certainly, I want to acknowledge that that's certainly within your prerogative. However, this stipulation would not be in effect. And I would go back to Supervisor Foy and work something out with him.
Yeah, the thing I was thinking of was I didn't remember any $1,000 limitation on it, and I think there's a distinction, or at least in my mind there would be a distinction between an honest mistake that led to a violation and a simple innocent failure to follow the law. In the latter, I'm not so sure that it should be, because everyone is going to then, of course, say it was an innocent mistake, and it's not a provable thing one way or another.
Well, let me add, I mean, I think it would be great if there were some guidelines in the future to say, regardless, you know, first-time offense, under a certain amount, doesn't get fined, or have some further qualification on it, first-time offense, but, and then add something else to that. At this point, I should add, in this particular case, I think it was an honest mistake. I do find there's enough, there's evidence that it should have been caught, but given that this is Supervisor Foy's first campaign, and he is a respondent for receiving it, you know, they're supposed to be reviewing their records. You know, they could have caught that, but I don't see any intentional wrong.
No maliciousness.
I don't see any maliciousness, and they did return the amount. They did return the overage within 5 days after they were notified by the Elections Division of the situation. So they complied. They complied as quickly as possible.
Mr. Chair, if I could just explain the circumstances. This, as you know, is really the first case that's come to you in which there has been found to be a violation. Mr. Hardy, as the attorney who's been prosecuting it, we had a discussion early on about how this should be handled in light of the absence of any guidelines that have been established. You know, other agencies, commissions who have been doing this for a while have developed with their enforcement staff, it's typically an in-house staff, a series of guidelines as to how to deal with various offenses. Is it a dollar for overages of excessive contributions? How does that work? Mr. Hardy had said, what should I do with respect to the, you know, my role as essentially the enforcement staff here, where I don't have any guidelines to follow. You know, it's obviously the commission's determination, and we're all kind of going blind here with respect to what the commission believes is the appropriate way to deal with these. And I did suggest that he look at what other agencies might do. I think the $1,000 limit he's referring to is essentially an infraction policy that the LA City Ethics Commission has established over time, where if it is a first-time offense less than $1,000, rather than treating that the same way as they do with other campaigns where they may have multiple violations or have had a series of violations over time, they do treat that as what they call an infraction. They note that there was a violation, so that essentially goes on the record, so that the next time it comes up, you're not eligible for an infraction and for no fine. But they deem that to be a different category, essentially, than those. And then I believe that's what's been incorporated in the recommendation. But just to be clear, it is your determination as to how you believe the particular facts of this case should be dealt with in terms of any proposed penalty.
Personally, I feel a little awkward now enforcing an ordinance term that isn't in existence.
Well, certainly, I mean, that policy is, I mean, if you're talking about the $1,000, yeah, that's not an element of the ordinance, nor, for example, in Los Angeles is that an element of an ordinance. That's just their policy that they have adopted over time as a way for saying, okay, we have discretion to impose nothing up to $5,000, up to 3 times the amount of the violation, which in this case would be $1,500. No, $1,800, I guess.
I gather that it hasn't resulted in any scofflaw attitudes.
I think the people who do business in the city of Los Angeles do not believe that there's much treatment of anybody as a scofflaw there. That they think it's a very rigorous commission there. They do perform audits regularly. They find a lot of violations, and they are typically dealt with on a fairly significant basis. This infraction policy, as I say, you only get one shot at that. It's typically for a first-time campaign. More frequently, it's even for contributors, because in this case, while the only allegation was a violation by the committee, it's equally a violation to make a contribution in excess of the limits, advertent or inadvertent. And that is the context in which, frankly, the infraction policy is most frequently applied, because a lot of the campaigns in the city of Los Angeles have large dollar volumes, larger than, at least at this point, in the county of Ventura. And campaigns typically have difficulty falling under the $1,000 limit for infractions, because the opportunity for violations is much greater. The law is much more stringent, and some of the demands on the candidates to keep in tow.
Any other questions or comments? We need to decide in this specific instance whether we follow the recommendation or whether we send them back to the supervisor for further discussion.
Well, in this case, we do not have any specific guidelines, which is, I quite agree.
Do you think we should?
Yeah, because that's the ultimate question. I mean,
Yeah.
it's violation. As it's written now, it's you either violated it or you didn't.
Right.
If I can add, Your Honor and Commissioners, under the current ordinance, you do have discretion to give a $0 fine.
Oh, no, that's right.
That is clear. It's not, the recommendation isn't asking you
That's
to do
correct.
anything that's not within your authority.
So,
I'm waiting to get some direction here,
so
actually.
what you're seeking is whether to accept this idea of a stipulated findings.
Or to send it back for further guidance.
Yeah, or I think there's a third recommendation, or a third possibility, and that is not on the basis of the guideline, which we haven't put into effect yet, but simply under our discretion, which we have the ability to do. I think that's also a possibility.
Yeah,
I'm a little leery of that because, unfortunately, everyone is going to be honest to forgive and forget.
Yeah, well, and you should be clear, I don't think that even the suggestion is that you should deem there to be essentially $1,000, any guideline that doesn't exist. I think that was just by way of comparison, if I
No, I
interpreted Mr. Hardy
understand
correctly.
that. That's not his recommendation.
Yeah, no,
No, I don't use the word policy in there, and I'm not meaning that we're establishing a binding practice either, or that there's a practice. I'm just making an observation that it's under $1,000.
Yeah, I mean, you essentially have two choices. You can either accept the stipulation or reject the stipulation at this point. If you accept the stipulation, then you're agreeing that for this particular offense, there should be no fine, even though there's been an acknowledgement that there was a violation. If you reject the stipulation, it would probably be helpful for there to be some guidance suggested as to what type of penalty would be appropriate for this kind of violation, because otherwise we have to have an administrative hearing at which the case is proved, and since the facts are not really disputed and are not really subject to dispute, you'd just be back before you at that point in time saying, okay, yes, we've proven there's been a violation, and now you as the decision makers have to decide what the penalty would be.
Assuming that everyone sticks with their story, we don't even need a hearing because all we need is a stipulated set of facts.
It could just be presented on a stipulated set of facts, and that's right, and it wouldn't even be a hearing. But it would come back again in that context for a determination as to what the penalty would be.
Still looking for direction.
I
I'm giving it, but I'm not trying to follow.
My tendency is to get further guidance on this.
From home.
The board?
Yes.
I think this is your call. This is not one. The legislation, the board, all the board can do is set out the range of penalties. You are now the judges.
Yeah.
and
We
the
said it,
administrative
and if the
agency.
board doesn't like it, the board can let us know.
The
Yeah.
board can let us know. Okay. All right. Then my inclination is to follow the recommendation of the stipulation.
Is that a motion?
It's not a motion that I heard of.
I'm concerned about precedent
Yeah, so am I.
and a loophole. And everybody gets a free bite at the apple. That bothers me a bit.
Yeah, I'm not so much worried about the free bite as long as it's not a big bite, as I am about the fact that we haven't set any guidelines, and I don't want to make this an ex post facto sort of a situation where we set it up only after the fact. I'm not offended by any of these.
If we follow the recommendation and then follow that with some action to have it come back to us for
to take a position on how we handle developing an answer to these situations. It won't just happen. We have to request that. Request that we have a discussion on excuse me, a better way of handling these violations.
Ms. Pennington, you want to make a motion of what you proposed, or Ms. Jones?
I will make the motion that we follow the stipulation and proposed decision.
And what?
And proposed decision.
I'll second that motion.
Okay, been moved and seconded that we follow the recommendation of the stipulation. And as I recall, I think it's not that we dismiss it, but rather that we don't fine.
That is correct, Your Honor.
Circumstances. Is that
You do
correct?
find a violation.
Yes, find a violation,
Yes.
but not fine.
Yes, Your Honor.
The supervisor. All in favor?
Aye.
Aye.
All opposed?
Ron?
I'm opposed too. And not so much for the idea of the thing, but that we haven't got any regulations on it at this point. And
It's not clear that we even need any.
yeah. Well, I don't know. That's another thing. I guess the motion has failed 2-2.
If I can add, you don't need regulations to make this type of decision on a zero fine. Certain agencies have guidelines to help prosecutors file stipulations with amounts that everybody has agreed will be dismissed. But I just want to make sure that you're aware that you don't need any further regulations to make this decision.
I understand that. My concern is that if we are to be a commission with any credibility, we should, except in extraordinary circumstances, levy the fine. That at this point.
Your Honor, may I ask guidance then from the commission on what type of fine?
Let me suggest something as well, because I know that we were advised by Supervisor Foy, who could not be here today, that if the stipulation was not accepted, he would like the opportunity to present the arguments in favor of no fine to the commission. So
would that go before the administrative hearing, or would that come before us?
It would come before you. You are, I mean, particularly, as I understand, under the ordinance and the period, you are both the administrative agency to hear disputes of fact, if there were some, as well as the agency that determines whether a violation would occur, and finally the agency in this instance, what we're discussing, to determine what the appropriate penalty is. And so all of that would come before you. And what I suggest perhaps what should be done now is, since the stipulation that was reached was rejected, we sort of start afresh, that the matter be continued and brought back before you essentially as an administrative hearing matter for you. If there's a stipulated facts, I mean, Mr. Foy has the supervisor has the right to withdraw from the stipulation and any set of stipulated facts to contest it if he so desired. My understanding is he only wishes to dispute and contest the penalty aspect of it. So it could well come back before you simply on a stipulated set of facts, but it would then be up to the commission to make a determination of whether there's a violation and then to assess appropriate penalty.
Not so much whether there's a violation, because I think if I heard you correctly, that's not contested.
Well, it may or may not be, depending. It's not contested in the context of this particular stipulation, but if the stipulation is rejected, the respondent has the right to contest whether there's a violation as well. He may or may not decide to do that, given the facts and given what's occurred up to date, but he has the right to do that and proceed again. So it would be back before you as essentially as a contested matter, in which at least the penalty aspect of it would be subject to presentation by one side or the other as to what the positions ought to be, and you then would be called upon to make a decision.
Today, our only action would be to reject it.
Correct.
And then what follows will follow on the basis of
Right.
application.
Yeah. Now, as I said, yes, and you have the opportunity, if you wish, to suggest what an appropriate penalty would be. But in the light of the fact that the Supervisor Foy has not had the opportunity to influence that decision, it may make more sense
Better
at
that
this
we
point
not
to just
do
wait.
it, I think.
So then it would be recalendared for an appropriate date at which it would come back before the commission for a hearing.
Okay. I think we've done everything now, have we? Everything clear?
Yeah.
Thank you very, very much. And we're simply of a different procedural opinion, I think, more than anything else right now.
I will proceed accordingly.
Thank you.
Thanks.
Would you like to make that in the form of a motion?
We already did,
Who made
to
the
reject the stipulation. It was a 2-2 vote.
It's 2-2.
Yeah, I think at that point, where it just carries
Motion
over then
failed.
as a pending item that will be resubmitted on another future agenda.
Okay. Mr. Williams, did you have comment on this one?
Well, I had to mark that one off. I thought it was mine again.
Okay, well, I just wanted to make sure I'm not passing you by.
No, you're not.
Okay.
Thank you, Your Honor.
You're welcome. Then item number 15, a recommendation for a stipulation and order on the Republicans for Ethical Government. Mr. Hardy.
Yes, Your Honor, and members of the commission, I've investigated case number 2006-09. Respondent is Republicans for Ethical Government. Per the stipulation, they have admitted that they basically spent $1,354 on an ad and that they failed to report that expenditure pursuant to Section 1275. And I have no evidence that it's not an independent expenditure. There was nothing on the face of any document that suggested it was not. My investigation was really related to, was this an independent expenditure, or I'm sorry, the independent expenditure was made, was a report made, and the report was not made, and they've stipulated that violation. I have recommended a fine of 1 times the amount that was expended on the ad, which would be $1,354. Respondent has agreed to that as well. So now we're in a similar situation.
Is this in writing?
Yes, this is assigned.
Because I didn't see it in my, is it in my agenda? I just pass it over?
Should be in your agenda packet. If it's not, we can certainly.
It is.
It came, my
Okay.
email.
It is. Okay, thank you.
You're welcome.
I just, in my experience, whenever I get an agreement between parties in a mediation, we write it down.
Yes. No, and we do have this in writing and stipulated too. So that is before you for your decision.
So the recommendation is to accept the stipulation, which includes the fine of the amount of the unreported ad.
Yes, and I recommended 1 times the amount that was spent because, based on my investigation, I didn't find any maliciousness or intentional wrongdoing. It seemed like this was a small committee that is not very experienced. But it was a violation, and it was a violation about an attack ad, which is serious. But I didn't find any aggravating circumstances that would lead me.
They weren't setting up a separate committee in order to dodge around it.
Well, I'm not aware of that. And that wasn't part of the investigation.
Okay.
That wasn't within the scope of my investigation as I received the complaint.
Any other questions? Do we have a motion?
I'll move to accept. Second.
Moved and seconded to accept the recommendation and the stipulation. All in favor?
Aye.
Aye. Opposed? You're batting 50%. Thank you. Thank you very much. Item 16, oral report on proposed amendments to the campaign finance reform ordinance.
Yes, Chair Peck and members of the Commission, at the Board of Supervisors meeting on Tuesday, April 17th, they had 2 items presented to them as it pertained to proposed amendments to the ordinance itself. One was actually brought forward by the County Executive Office with a recommendation that was prepared by County Council, primarily as clarification of intent of the existing language, and that one pertains to Section 1270 of the ordinance, and it indicates that limitations are solely on contributions and not limits on amount of expenditures by independent expenditure committees. The other items were brought forth by Supervisors Bennett and Supervisor Long, and there were actually 6 different items proposed by those board members. The first one was revising the point at which non-participating candidates' expenditures release participating candidates from the voluntary expenditure limit. At the present time, it's set at 75%. They're recommending that it be reduced to 25% to lower that threshold.
I'm not sure I understand what you just, I'm sure you said it right, but I didn't.
I'm actually reading it from the board letter. Oh. At the moment, participating candidates, those individuals who accept the expenditure limits, are released from the voluntary expenditure limit, in other words, how much you can spend, when the non-participating candidate reaches 75%.
Oh, okay. Now
and they're recommending that be lowered to 25%, because what they're saying is if that non-participating candidate waits until the very end and spends a great deal of money, it doesn't give the other person much of a chance to then get their own activities going, to exceed their limit for expenditures. Does that make sense?
Yes.
I don't know if I explained that very well, but I was trying to explain it the way Supervisor Bennett explained it. And then the second item was to enable the Board of Supervisors to reappoint members of your commission directly without going through the independent selector process, where they have to come up with 3 names and then bring those forward to the board. For members who are now seated as commissioners, the board would be able to do a reappointment directly without doing the independent selector process. The third item was an adjustment of the contribution limit itself. As you know, it's now $600. What they're recommending is that based on CPI changes, that be pushed to $700. And the fourth item is one that I think will be of interest to the Commission. The supervisors are going to be considering establishing a procedure whereby the members of your Commission will no longer do probable cause determinations on complaints that are filed. Those would go out to outside attorneys for determination, for what we would call initial review instead of probable cause. Item 5 would be to revise reporting requirements, and those really are designed to be consistent with state requirements. And the same, I believe, is with item number 6. And those will be presented to the board Tuesday as part of a consolidated proposed amendments to the ordinance.
Any questions? Thank you very much. What? Yes. You need a motion?
Yes, please.
All right. Need a motion to receive and file those.
Move to receive and file.
I'll second.
Okay. All in favor? Aye. Opposed? Done. Okay. The last item on the agenda is to receive and file a letter, although I think it's really more just a DVD from Mr. Williams. Am I correct?
Yes, Your
Honor. Okay. Is it all right if we just play the DVD?
Yes, it is.
All right. Then.
Since I've seen my close-up many times, I'm going to recuse myself for this.
Oh.
I'll come back out.
Okay.
Mr. Williams has any questions.
How much time do I have left?
No, you know what?
fake public meeting, and you are, you know what, I'm on the Ventura County Campaign Finance Ethics Commission. I sat a month ago and listened to Carol Dean Williams call us assholes, you know, oh my God, assholes, this, that, and we had to just sit and listen politely. You are a fascist. People have a right to free speech.
Excuse me, darling.
You know what? And I was exercising that process. You...
How much time do I have left?
You're going 150, 149.
I requested this for two reasons: of my right to publicly criticize this board, and for my right to First Amendment speech, which Ms. Jones acknowledges in there, and to correct the record because my name is used. I never call this board assholes. I never did that. It's on the record. I will state the record again, and I believe this will apply to Captain Norris now and the fascist Ventura County Sheriff's Department. Captain Norris, if you make a decision when you don't know shit about a subject, you are an asshole. And I think Ms. Jones would agree with me on that, because the way she was treated has the same criminal penalties that this ordinance has. Why don't you change this ordinance to all civil penalties and fines and forget about the horse shit of criminal penalties, because it will never happen. It's got to be sent to the DA within 24 hours. What does the DA do? Where is the DA here? I just heard there was a violation. That violation, whether you find it zero or what, is a criminal penalty. And I just heard you try to dismiss criminality. That's not the way our laws work. Ask Captain Norris. You should have had him here to understand the way the law works. What was wrong with his judgment? Yes, Miss Jones was brutally assaulted and battered that night. Thank you.
Mr. Williams, could I just make one comment?
Sure.
I would very much appreciate it if you would leave out the scatological termination. I mean, I can swear probably almost as well as you, but I don't do it in public hearings. I would ask you, please, if you could not do that sort of thing. It demeans us all.
Thank you.
Sure. Okay, any other items on the agenda?
I just would like to make one comment, Mr.
Oh, excuse me,
Williams.
I'm sorry.
I hope that it was clear to you that I was supporting your First Amendment rights and continue to do so, and admire people who have the guts to stand up and say what they think, and as opposed to the apathy that so many people experience. And I hope that that was clear to you.
Thank you.
Anything else on the agenda? Any other comments?
Chair Peck, I just wanted
Yes.
to note for the commission that we had indicated on the agenda the possibility of tentatively scheduling your next meeting on Friday, May 11th. I would like to consult with our investigators to see what would be ready and whether or not that would be a good date. We may need to push it.
Just simply just whether there's enough agenda items to make it worth it?
Right, to make it worthwhile to bring the commission together. So we may actually be looking for a date in early June instead, but we'll do our email and phone calls.
You want to poll, I think we've got everyone here now. You want to poll on possible dates?
If you would be willing to do
It's all right
that.
with me, if it's all right.
For the 11th?
11th of May.
Yeah, I had it written it down. It's okay with me.
It's fine with me.
And how about early June if the 11th of May is not going to be a good time?
Fine with me.
What's the first, or what day in June?
There's June 1st
Early
and
June.
June 8th.
June, either's fine with me.
Okay. How about the other members of the commission,
Fine.
June 1st or 8th?
I believe the
And you prefer to stay with the Friday day? Friday as the preferred date?
yes.
That's all right with me.
And this time period again?
Sure.
Okay, so we'll keep those tentative dates and then notify you.
Okay.
Thank you.
Thank you very much. If there's nothing else to come before the commission, the meeting is adjourned.